So I feel today is, like we are really lucky to have you. So all yours now.
Thank you, Arpita. Yes, today's topic is quite important, and because it involves legal aspects. So parents, families who have got a special need child, so there's very less awareness on most of the legal aspects when uh, when we look at it. One second. Yeah. Yes. Okay, so basically, a lot more about me. So, what I am representing is Special Need Estate Planners Private Limited. Now, that's a company we formed in 2020 and completely focused on advising special needs children families. And we work on estate and succession planning matters. What I'm going to discuss today, all the aspects, and we have been working with families on all those aspects, and not only families, we have working with families. We are also working with residential homes which are there in India. We are also working with them, advising them on their aspects, and plus families who are uh, planning to have their child residing there, and we are working on their legal aspects also. So, what is the objective of this session we are doing today? So, we'll understand key issues for consideration by special children families, especially on the legal side, because it involves a lot of aspects which you have to address. We'll understand about will, trust, and there are other some legal aspects, roles and responsibilities of various stakeholders, what how they are going to be important in the life of a special need child. We look at what are the options for managing the child care within your lifetime and post your lifetime, how the transfer of assets will take place for the benefit of the special child. So what are the options, what the law says, and what are the options parents have. What are how you provide the security of assets so that it can be utilized only for the benefit of special child, and how the steady income stream will be built. So I'm not going to go on financials today. We have already spoken on that earlier. So today we'll be talking more on the legal aspects. First of all, estate planning. Why estate planning is so important? And Yes, it's important for everyone, but with a special need child, it becomes more important because there is lot more legal aspects which needs to be addressed. So in general, an estate planning, when we are talking about, so now there's a confusion that we are talking when it comes to word estate, it means real estate. No, an estate is all your personal estate. So all your personal assets, movable or immovable. So your bank account, your lockers, the valuables you hold, your properties, the investments. So all this comprises of your estate. How your estate should be utilized within your lifetime and post your lifetime, when you do planning for all those aspects, then we name it as estate planning. So estate planning means how your wealth or your assets should be utilized for the benefit of yours and benefit of your legal heirs after your lifetime. So generally, estate planning, the objective is that maximize inheritance to legal heirs, address any kind of taxes and expenses which can come up in the future at the time of distribution. The testamentary instruments are generally like will, beneficiary designation. So whoever is the beneficiary in your will, so we had to review those designations, and we have to ensure that the money is going to go to them. Determine guardianship of children. So when you have minor children or special need child, then all about guardianship. Who's going to be the next legal guardian? We'll talk on that. Distribute assets to beneficiaries. How the assets are going to be distributed to beneficiaries, in what manner, and managing estate assets. So whatever properties you have built up, who's going to manage and in what manner. So when we are planning for all these, we are talking about estate planning. Now, before I go into each elements, first look at, as a parent, when you are thinking of that, how I can protect my assets for my child and how the asset should be utilized for the benefit of my child. So then uh, the most viable thing is that analyzing what options do you have within the legalities framework, because the legal issues will come into picture. So within this legality framework, what options do you have? So when we talk about estate planning options, and I'm talking specifically from the point of special need child affairs, it will an estate planning may involve lot many other aspects also for your lifetime also, but I'm talking more from the specification of special need child affairs. So distributing assets to sibling family member for special need benefits. So one option is that the assets after your lifetime goes to any family member or to sibling, and who manages all the affairs, including the financial affairs for the child, or you gift or bequeath asset to the child only and it will be managed by the legal guardian. So I'm talking more on the financial aspect, not on the personal affair, but all the financials, when it comes to who's going to manage the financial. So what are the options you have? So if there is a sibling, you can give everything to the sibling, he'll manage the child affairs financially, or you can give it to the child directly and that will be managed by the legal guardian, or we can set up a special need trust and give or bequeath to the trust, so it will be managed by the trust, or distribute asset to the residential living home. So if you have opted for a residential living home, you can give whatever wealth you have accumulated for your child, you can give it to the residential living home for the child benefit. Now, these are the estate planning options you have when you are looking at considering the security of the financials for the child. Now, which option suits your family dynamics? What is going to be best for you? That you have to analyze and decide. But we will talk about certain elements of these estate planning which will make things easier for you to decide and how you work on these. So let's talk about why write a will. Okay, will is the most important element of our life. I'm not talking about even in general also. Uh, if you have to distribute your assets as per your wish, then will is important. Now, what happens when you don't have a will? See, the legality says that there is a succession act which says that if you do not have a will, then whoever are your legal heirs, wife, children, mother, whoever are your legal heirs as per the Succession Act, what they have defined, just give equal to everybody. Okay. No talking about trust, nothing going to trust, nothing more, nothing less, give everything to everybody. So if you have 100 rupees, 5 legal heirs, give 20 rupees to each. Now, that's what the law says. When you are not writing a will, this is how the assets are distributed. Now, this is not what you may want, because you want to leave something more for the special child. You want to describe that how these assets should be utilized, how this legacy should be utilized for the child benefit. That's why will is written, and that's why will becomes important, because you want your assets to be distributed as per your wish. So what does the will do? It provides specific bequest and direction in your will for the benefit of your child. So those specific directions, the specific bequest that this asset should be for my child, these are the assets which should be there for my child. This can happen only in the will. So when you are writing a will, you provide specific bequest and direction in your will, and it can in the will it can mention that this corpus is going to be utilized for his or her maintenance and medical care and all other requirements. So you can specify in the will that this is how the money is going to be utilized for my child benefit. And bequest can comprise of home care in your residential property. So if you have a residential property and you want your child to stay there, he should be his care should be taken living in that home only. So you can give that direction. Appointment of legal guardian after your lifetime, after parents lifetime, both parents lifetime, who is going to be the next person who will take decision on child behalf? The legal guardians. Who is going to be the next legal guardian? See, from the legal perspective, if you do not appoint the legal guardian, the matter will go to the court, because the court will appoint the legal guardian, the national trust or probably the court. Now, no parent want the matter, going to court. So it's important that you appoint the next legal guardian. You mention the person who is going to take care of the child personally. Setting up of a trust through will. So we'll talk about living trust and testamentary trust. An appointment of trustees, successor trustees. So you can appoint people who's going to manage the financial affairs for your child, and provision of distribution of income of the trust. So how the income of the trust is going to be distributed, that can also be mentioned in the will. So if you look at the importance of a will, now from these you can understand that why a will is important. Now, if you do not write a will, nothing of this is going to happen. And the simply all part of your asset equally distributed between your legal heirs. And that's what I said in the beginning, that that is not what you want. You want the money to be utilized for the benefit of your child in a certain manner, and with all the provisions which is there are on your screen. And this happens only through a will, and that's why will is so important document. And how the corpus distributed upon the demise of the child. So if you form a trust and if you name everything, if you've given everything to the trust for the benefit of your child, how that corpus is going to be distributed after the lifetime of the child, that also you define in the will. So will, it becomes a very important element. The checklist for creating an effective will, not a rocket science, but a simple homework. Just prepare a list of your assets and properties, taking account whatever debts and liabilities you have to pay. So this and that will tell you that which liability to be paid from which asset. Make your intentions very clear in the will. Write everything in plain, simple language. Okay, write everything very clear. This is how, this is where the money will go. This is how the money will be utilized. No ambiguous clause. Avoid any ambiguous, contradictory, or the words where things are not clear. Avoid writing those words. Avoid making errors. If you wish to disinherit any family member, state the reason. Whatever you are doing in your will, state the reason why you are doing so. That makes your will very clear. If you want to leave more for special needs child, state the reason. Don't just write that I am leaving so much money to my child. Okay, if it is more, there is a sibling, clearly write the reason why you are doing so. Sign on every page of the will. Attach a doctor's certificate for authenticity of your sound state of mind. Let the executor know about your will. So whomsoever you are appointing an executor in your will, let the executors know. And review your will every 3 to 4 years. There might be changes, some assets you have added, some assets you have deleted. So you can review the will and you can redraft the will also. And always take professional help to validate of what you have written. So if you want to write an effective will, just take note of these elements. Okay. So that was on will, and it is a starting legal point in your legal planning, but most important point, because everything will happen through how you are going to write a will. The next concept is living will. Not many parents are aware of. This was implemented by Supreme Court in 2012. Now, what is a living will? Will talk about the will I have spoken earlier talks about your wealth, your estate you have created, how it is going to be distributed. A living will is basically an advanced directive for physician. See, why this living will concept actually came in India. It is there abroad in many countries. It is mandatory document. Now in India, we are seeing a lot of families. There is a financial implication happening on a lot of families where if one of the family member is hospitalized and the situation get prolonged, then the amount of financial constraint it brings to the family is huge. We know how the hospital bill runs. Okay. And for families, it is always a difficult decision to take, that, in critical situation, what should they do? So to avoid the financial implication, these living will is written. Now it's an advanced directive for physician, basically relief from the pain arising from prolonged medical care. Most critical situation where things get prolonged, you do not know what is the outcome. It actually relieve, from those prolonged situation. And in a living will, you can instruct to remove all artificial prolongment of life if situation is irreversible. So we are talking about those, that critical situation where there are, so from the doctor's perspective, the situation is irreversible and you are surviving on artificial things. So for a family, it's always difficult to decide. And we have seen those kind of situations. So a living will is basically for those situations where the financial implication can be reduced, because it, talking about not on personal front, but the financial implications are huge for these situations. So a living will is written for those. And for a special child family, I think anything which can come up, which can reduce the financial burden on the family, that's a good document to consider. So that's a living will. Now, elements of estate planning, what is there in estate planning? Okay. Uh, we'll talk about first guardianship. Now, guardianship is the most important aspect, and a lot of challenges are also there when you talk about legal guardian. But there are few legal aspects which a family should be aware of. First of all, the first legal guardianship you have to address is when the child becomes 18. So till the child is 18, you are a natural guardian of the child. But the moment child becomes an adult, then natural guardianship ends. So that's where you have to take the legal guardianship. So the National Trust Act comes into picture once when the child turns 18, because now the parent have to seek the legal guardianship. And the National Trust Act is created to give legal guardianship certificate to parents who apply for it. So basically, it's one of the alternative of the court procedure you have. Testamentary guardianship is when you are writing a guardian in the will to appoint a next person. That is called a testamentary guardianship. So it will come into picture when you are writing a will. Indian courts will appoint whenever there is, say you haven't appoint a guardian in your will. Okay, then the Indian court will appoint the guardian. The trust setup can also have that provision, but it has to align with the laws, the legal guardianship laws of the country. So the key factors: natural guardianship ends once the child is an adult. The moment child turns 18, natural guardianship ends. So when the child is minor, you as a parent deciding everything, writing a check, investing on the minor name, doing an FD, making all the decisions. So that's a guardianship. Now that's a natural guardianship. The guardianship continues for a special need child, but it converts from a natural guardianship to a legal guardianship. So once the child 18, you are not a natural guardian, you are a legal guardian now. And to have a legal guardian, to become a legal guardian, you have to avail the legal guardianship certificate. Without legal guardianship certificate, you are not an authorized legal guardian. So if the situation comes where you have to decide on the child behalf and you have to sign papers as a guardian, you won't be able to do that until you have a legal guardianship certificate. Parents to appoint next legal guardian in their will. So in the will, you appoint the next legal guardian, or even when you are applying for the legal guardianship, they always ask for an alternative. So you are going to appoint the next legal guardian. As I said, if you do not appoint, then it is an open thing. Probably the matter will go to the court and court will appoint the next legal guardian. Now, legal guardianship, how do you apply? So you apply through National Trust, or then the RPWD Act which has come up. Uh, it has a provision of applying the legal guardianship through district court. It talks about limited guardianship. So there is a difference between limited and full guardianship. A limited guardianship is only guardianship for certain matters, but that has to be with the consent of the person with disability. Largely in special children families case, it is going to be the full guardianship which the national trust is giving. But when you apply through district trust, district court, then probably they look at that whether it should be a limited guardianship or uh, full guardianship. Wherever national trust provisions does not apply, okay, like say for example, national trust clearly says that people living beyond India uh, cannot apply for legal guardianship. Now as a sibling you are the only family member, or suppose your child is not an Indian citizen, he is a US citizen, but now you are settled in India, the child is going to live lifelong in India. Now for that situation, National Trust might not have a provision. So you will have to apply it through a district court. So like this, there can be family circumstances where National Trust won't help, and you might have to go to the district court to get the legal guardianship. But legal guardianship is one of the important element in your child life, and you as a parent will have to take a legal guardianship the moment child turns 18. And legal guardian manages both personal and financial affairs. Whatever is going to be there in the name of the child, anything financially, that is going to be managed by the legal guardian. So there is a roles and responsibilities written in the legal guardian. We have also created certain guides on legal guardianship, how to apply and what are the role responsibilities of a legal guardian. That will make things clear for you that what all you have to manage as a legal guardian, what all the future people will have to manage. Checklist for a guardian. So whenever you are appointing the next guardian, you have to just ensure that the person you are appointing, uh, one, he is aware of your child needs. He can manage the financial affairs if you are leaving financial affairs to him. Okay, the comfortability of your child with the next legal guardian, and where he's going to reside, how he's going to take care. If your child is going to reside in a home care, okay, in your own home, so the next legal guardian, wherever he's going to reside, how he's going to take care of the child. So all that you have to see when you are appointing the next legal guardian. Okay, the next is not a legal document, but from an estate planning perspective, a very important document. We call it a letter of intent, or it clears out your vision for your child. Now, so let me ask you a question. So, if you are leaving your child, say for say 2-3 hours in your to your neighbor, probably you can give verbal instructions. But if you even if you leave for 28, 48 hours, still you can give verbal instruction. But if you have to leave your child to somebody for the lifetime, can you give verbal instructions? No. So you need a certain document which can ensure that the person who is not going to be as aware as you are, because you are a parent, you are managing your child affairs, you know everything. He might not know everything. Okay. So letter of intent becomes a document which can be shared with those stakeholders, which ensures that if they need any information or to understand about your child, they can refer to this document. What does a letter of intent says when it writes? So it describes about family, describes about the living, daily routine, habits, the foods, the residential option, current residence, the future option, what is not going to work for your child, the healthcare, the medicine, the any issues, what hasn't worked in the past, what is how the legal guardian should look at the social activities of the child, the education of the child, the religious activities of the child, what are his likes, dislikes, and the final arrangement. So if you look at the letter of intent describing everything about your child, somebody who refers to this document can understand more about your child, with a list of people whom to contact if anything in any information is required. So the role of a legal guardian eases out when you are giving this document to the person or to the stakeholder. It can be also given to the trustees also, probably. So letter of intent is one important document. In fact, this is the first document I always say to, the family should write. Many things get clear, and even within spouses also, if one spouse is taking care 24/7 and one spouse is working, there would be some information which, the spouse who's taking care 24/7 would have more information than the other spouse. Okay, these things, when you write down, sit and write down, these things are pretty clear. Okay, so let's talk about a private trust. Whatever elements I am discussing today, these are all elements of estate planning which are important for special children families. So I've spoken about will. No doubt it's the most important document. I've spoken about living will. It is an important document when you talk about the implication, the financial implication of different life situations. Okay, letter of intent is an important document to be given to the stakeholders to refer to when they want to understand about your child. Guardianship is highly important because you are going to decide who's going to be the next guardian, and you also, as a parent, have to take certain decisions, have to sign papers on child behalf. You will have to take a legal guardianship. So let's talk about private trust. Uh, the estate planning options I spoke about. So if you are not leaving financial to the legal guardian, what option do you have? Okay, sometimes what happens is that you do not want to burden a legal guardian with both personal and financial affairs, because as a legal guardian, he or she is an individual. So you will have to think of that. What if something he is also not there tomorrow? Can there be next person? So can you have a continuity of managing the child financial affairs that a trust can do? So what is a private trust? So what are the benefits of private trust? One, there is no restriction on settlers or those who can create the trust. So parents, grandparents, even the guardian, the well-wishers can create the trust for the benefit of the child. There are no standard terms. So each family can write terms of the trust as per your own requirement. How do you want to manage the trust? Who can be the trustees? You want special provisions that can be written down in the trust. Separate entity altogether, does not go through a probate. Okay, so it does not go through any court process. So what happens is that, say, suppose execution of will. Now, during execution of will, things happen. A will maybe go for a probate. So it will take time. Till that time, the assets won't be distributed. But a trust will continue managing the financial affairs. Okay, so it brings the continuity of the child affairs irrespective of what's happening with other situations. Whoever create the trust can appoint initial trustees. So when you are creating the trust, you can appoint the people as initial trustees, or you can be also the trustee as a parent. A trust works only for the beneficiary. There is no other objective of the trust. Its objective is to manage the assets and provide benefit to the beneficiary, that is your child. Most importantly, it avoid any conflict among family members. So whatever conflict comes with respect to the financials, a trust will avoid that, because family members know what is the objective of the trust, that to manage the special child affairs. So things are pretty very clear, and that's why trust can avoid conflict to a great extent. Living trust. So a living trust, we call it. So there are two kind of trust: a testamentary and a living trust. Testamentary trust is when you leave the trust formation to a will. So in your will, you write that whenever death happens, then at that point the executor would create a trust and transfer all the assets for the benefit of my child to the trust at that point of time. But there is a provision of living trust, which is basically you create the trust in your living only and make it functional while you are living. Okay, so you create the trust today. You create the trust deed today, you create the structure today, you create the framework today, you appoint trustees, and you make it functional and start transferring the assets to the trust. That is called a living trust. So who can create? Parents, grandparents, legal guardian, terms, not standard, whatever uh, whatever is your family dynamics you want, you can create. Legality, it's a separate legal arrangement. Okay, assets owned to the trust only for the beneficiary. So assets are transferred to the trust only for the beneficiary. No other person can take the benefit of those. Protection to assets. So once the assets are transferred to the trust, they can be utilized only for the benefit of the child as a beneficiary. Trustees, so there is very less legal foundation on who can be trustees. So parents can be initial trustees. So you have created a trust, you can also be the initial trustees, manage it. Friends can be there, family members can be there, professional trustees can come in uh, as a trustee. And formation, so how do you form a trust? You decide the structure, what structure you want. So there are various structures, revocable, irrevocable. I'm not going very deep into those kind of structures, but put simple, a revocable trust, I'll talk about. So you decide the structure, what do you want to create? Decide who will be the trustees, you decide the beneficiary. So why I'm saying decide beneficiary, so yes, you're creating a trust for the benefit of the child, but sometimes if you look at, so quite a few families have more beneficiaries. So parents have themselves become the beneficiary of the trust because they are getting old, and they in their old age they want the trust to manage their affairs also. Okay, so you can decide how do you want the trust to decide the funding, how do you want to fund the trust, from where the money would flow and in what manner. So once you have decided that, then you draft the deed and you register the trust deed, your trust is functional. That's how you form a trust. So that is a living trust. You create this framework while you are living. I'll talk a little bit about trustees. So trustee is basically a individual who's going to manage all the properties, an organization on behalf of some other individual or a third party. So when you name a trustee, even a legal guardian is also a trustee. A trustee of those assets managed for the benefit of the child. And trustee is supposed to make profitable decisions only for the entity. They don't have any other job. They don't have any other role. They don't have any interest in the trust. Their interest is only that they manages the assets, pass on the benefit to the beneficiary. Who can be trustees? Anybody can be trustees. A corporate can also come in, bank, their trust come there. It can be combination of individual and corporate fiduciaries. So you can have any formation, any structure, any number of trustees. Okay. Yes, you can have a professional trustees also. So though you appoint as a family members as a trustees or friends, individuals, but you can have a professional trustee also. Now, professional trustee, the role is only that he is a person or a company who will act as a trustee of the trust. Okay. Their interest is only to manage the asset, pass on to the benefit to the child. They are not a beneficiary of the trust in any manner, and they are not entitled to share in the asset of the trust. So they are a pure professional. They are a professional for managing the trust affairs. So like a private limited company, when you appoint a CEO, so what does CEO do? CEO role is only to manage the affairs. On the face of it, he is given a salary. Similarly, professional trustees manages the affair of the trust. For a fee, they charge for managing this role. So SNEP, our company, also acting as a professional trustee in private trust. The role of professional trustee is only to check that interest of the beneficiaries are concerned, that assets are protected and the trust is running correctly. Functions, if I talk about what they do, so like arranging meetings with other trustees, making all decisions along with other trustees, existing investment policies of the trust and discussing with trustees how these policies should be changed, signing appropriate document wherever they required, ensuring all decisions the trustees make in affair of the trust are correctly. So all record keeping they are doing, they are ensuring that the trust records are managed properly, whatever assets are coming to the trust, gifting. So they are managing the day-to-day affairs. A professional trustee will manage day-to-day affairs of the trust along with other aspects. And whatever is the function of the trust, the affairs of the trust, the professional trustees are going to manage that. They are experienced, they are charging a fee for that. So they will charge a fee on the basis of holding the position of a trustee, and they will charge for the work they do on behalf of their co-trustees and behalf of the trust. So like if professional trustee can charge a fee for preparing minutes and executing documents, or a professional trustee can charge a fee for the complete managing the complete affairs, whichever way they charge, but a professional trustee will charge a fee. Why a professional trustee can be thought of? I'm not saying it's never a mandatory. Whomsoever you want to appoint, you can appoint a trustee. But professional trustees would be well acquainted with trustee duties. chances of allegations of sham trust get decreased, because he's a professional, he's managing things, and he's not going to manage alone. He's going to manage with other trustees who might be a family member, might be a friend, and they are personally liable to all the beneficiaries. So identifying trustees, professional trustee you can look at, you can identify, but when you are identifying trustees as an individual from family members or friends, if you want them to a trustee, so you have to look at certain qualities, like the so whether the person know how to manage the about investments, account, taxation matters, might not be an expert, but at least he should know whom to contact, how things are going to be managed. He should have a knowledge of how things have to be decided. It might happen that the trust might have a good amount of assets, so he will have to decide on that. Should be able to manage relationship. It's about special need child benefit. So he should have an understanding of special need child, life stages, his requirements, so that tomorrow if he has to take a decision on certain expenses, he should know why these expenses have arisen. And it does arises when it comes to special need child affairs. So that understanding is required. And avoid conflict. So that's one of the primary qualities you look at. And as I said, individual or corporates or professional trustees can come in. So whenever you are appointing somebody as a trustee, look at from that perspective that he is going to fall into your shoes. The way you think of about the future of the child, so a trustee will also have to think of, if I am not there tomorrow, then whether this corpus is going to be sustained, how should I make this corpus sustain longer for the lifetime of the child? What are the child requirements, so that an understanding is required from the trustee point of view. Okay, this I have spoken about the special need trust. We in India we do not have a definition of special need trust. It's majorly about private trust. So in India everything is about under public and private trust. So what we are talking today is private trust, private family trust, a family creating a trust for the benefit of a family member. This I have largely spoken about. So, stakeholders, who are all the stakeholders? Okay, the stakeholders are guardian, who's going to manage the affairs. So even if you form a trust, you will still require a legal guardian for the personal affairs. So the guardian will always be required. Then there are trustees, who's going to manage the financial affairs. There is a support, family members, friends, parents, community. So who will fulfill the role of parents whenever there's a need. And then there are service providers like residential living centers, medical professionals, organization. So these four are the important stakeholders in your life, because these are the four stakeholders who are going to look at your child affairs for the lifetime. And when you're talking about creating a framework for your child, it's important that all these stakeholders always work in sync with each other. It doesn't happen that a guardian does not know what's happening with the private trust. A private trust does not know who is the guardian and where he is living. It should not happen in that manner. So a trustee will always be working with legal guardian, and both private trust and legal guardian will have the support of the people beyond them. And service providers will be in touch with the trustees or guardian. If the trustees are managing all the affairs, service provider may be reporting to trustees, and or having an arrangement with the private trust, and private trust is reporting to the legal guardian, whichever way framework you decide. But it's always important that all the stakeholders are binded together. This we conceptualized last year, that you have to create an ecosystem, not just a document. Legal document is fine, a professional can work out this legal document, but how do you ensure that your child care is done properly after your lifetime? Now that depends on the ecosystem you build. Now what is this ecosystem all about? As I said, there are stakeholders. This ecosystem is talking about bringing all the stakeholders under one roof. So ensuring the trust becomes an important entity here. So when you form a private trust set up contracts with service providers for all the services they require. So it can set up contract with residential homes. It can set up contract with different service providers, and a trustees will always report to the legal guardian. So the legal guardian would know how the trust is functioning and what's happening with the child affairs. So like this, you create an ecosystem with a periodic review processes, which ensures that things for your child affairs, the system you have created for your child affairs is going to work properly even after your lifetime also. So we always believe that do not create just legal documents, create this ecosystem, implement this ecosystem in your child life.
There's a question in the chat box. Would you like to take it now or later?
Just give me 5-10 minutes. I am completing the presentation and we'll take up
Okay,
all the
okay.
questions. Okay. Okay. So I'll talk about now funds required. So you have formed a trust and have done everything. How do you decide how much is the fund required? Because one way is that you have an idea, okay, I leave 50 lakh or 1 crore to my child life. But for the trust, it is there's some cost implications when you're forming a trust, and you always have to leave something more in the trust. But so how do you decide on the funds required? So I'll just take a small case study. Vicky, 27 years old, especially adult. Gaurav is to estimate corpus required for lifetime care. We assume life expectancy for Vicky to be 70 years. So average inflation 7%, and let's say the money is going to grow by 8%. This is a chart of wiki expenses. Don't go on the numbers. These are all hypothetical numbers I have taken. But this is a kind of an expense sheet we have we prepare for special need child, working out on the child expenses, living, day-to-day care, personal needs, schooling, special equipment. So this, when we do financial planning, so we separate out the child expenses. So from this sheet, if we say suppose 58,000 is a monthly expense today for Vicky, which means 6.96 lakh is the yearly expense. And 27 is the today age, 70 years. So that means as a parent, Gaurav has to plan for 43 years of lifetime, which means Gaurav is planning that if something happens to him today, this amount of money should be there for Vicky. Okay. On numbers, this corpus will come to around 2.4 CR, which means if 2.4 CR is there with Gaurav today, then he can take care of Vicky's expenses for Vicky's lifetime. Even if he is not there tomorrow, then this amount of money will fund Vicky expenses for the lifetime. This is most important because you form a trust, but if you don't fund with adequate money, trust can't do anything. The financials have to be provided by the parents only. And that's why these estimations are important. Uh, this is only a different variation of that you can take inflation separately, medical, other expenses. Corpus for the trust. Now let's say corpus for the trust. So for Wiki, it is required 2.4 CR. Now there might be certain cost implication for the trust. Say administration, there is a 50,000 annual expense. Income tax, there is a 20,000 annual expense. Other expenses might be 20,000. So the yearly cost for trust management would be 90,000. If I look at from that perspective, then the corpus would be around 2.7 CR, which the you have to fund the trust. Okay, with this corpus, those are the trust is able to take care of wiki expenses for the lifelong. So this is how you decide on the funding of the trust. You work out the funding of the trust, and this is going to be most important because not even the trust, without the trust also, if you have to decide on how much money should be left behind for my child, this is how you're going to do, and this estimation is very, very important. Okay, I was talking about ecosystem, so I'll do just one case study. So Varun, 42 years old, is a special need adult. Varun father is 75 years old. He wants to plan for Varun for his considering his old age. Varun mother died 10 years ago, and immediate family member is younger brother who is NRI. His brother's son is also NRI, but Ravi wished to involve him to oversee Varun care. So Ravi wished to have Varun stay in their existing residential home. So what is the ecosystem which can be built? So if you look at, I'll explain this chart. So in between, it's a family trust, which is most important. Now, Ravi as a settler, so Ravi is a settler and Ravi is also the guardian, the parent, the father is the guardian at that point of time. So he appoint the future guardian. So one second. So he appoint the future guardian and caregiver. He set up the terms of the trust and appoint initial and future trustees. So Ravi is planning for the Varun future. and he plan everything. So he formed the trust. He appoint people as future guardian. He set up the terms of the trust, and he appoint initial and future trustees. Now the brother son, who is an NRI, he wanted to involve in managing the affairs. So he appoint him as a protector. There is a role of a protector also, that somebody who cannot become a trustee, you can involve him as a protector. So brother son is always going to be involved in the trust affairs and will oversee the trust affairs. He set up appoint professional trustees who will manage the day-to-day affairs. And now, what does this trust do? So the trust set up contract with the service providers, because the child is going to stay in the home. So the trust takes the center stage and it's a set up contract with service providers, institution, medical professionals, and all other professionals. And the child care is being taken from these these service providers, ensure that the whatever support is required for child care is being done. And the funding of the trust happens through investment, life insurance. Now the trust always report to the protector. Okay, so the protector is there who is overseeing the affair. The trust is setting up contract with service providers. They will set up a review system also, and the other stakeholders will also come into picture. So whoever is appointed the next legal guardian, he will be involved in this ecosystem. So like this, in ecosystem you have to create which ensures that it's not only about those legal documentation, it's about how those legal framework work, in what manner, which ensures that the child care is not left behind from any perspective. And that can happen only when you create this ecosystem. Okay, that's probably from my side. We what we do as a company, Special Need Estate Planners Private Limited. So we work on these estate planning solutions. We work on this ecosystem, will trust creation. We do work on the legal documentation. We have trusteeship and trust advisory services for management of the trust. This I have already spoken about, so I'm not going to speak much on this. Yes. I'm happy to take any question and answer.
Yeah, there are a few questions in the chat box. Uh, One is, what is the difference between a protector and a legal guardian?
Okay, so legal guardian is about the personally about your child. Okay, so a legal guardian is somebody who's going to manage your child affairs personally and financially, right? First of all, let's separate out legal guardian and trust. They both are separate. Legal guardian does not have any role with the trust. Okay. A legal guardian is a role under Indian laws where somebody, if somebody is incapacitated or not able to take his decision, then you can appoint a person who can take a decision on his behalf. And that person is called as a legal guardian. So legal guardian has an authority to take both personal and financial decisions, both. So that's a legal guardian. Protector is a role under a trust only. Okay, so protector is like so NRIs. It's very difficult to appoint NRI as a trustee. So what happens? What happens is that when you cannot appoint a trustee, so it's a private trust. You can involve as many people as you want to manage the affairs. So you bring a role of a protector, that the person would oversee the affairs, would be part of the decision making in the trust, but he won't be a trustee. He won't be looking at day-to-day affairs. Okay, so his legal liability won't be as a trustee. He will be there just as a protector to oversee the affairs. So protector is a role under a trust, nothing to do with legal guardian. Legal guardian is completely separate.
Yeah. The next question is, living trust a separate legal entity for taxation purpose under Income Tax Act?
No, whatever is there, private trust, living trust is a name given to a trust which is formed in your living. There is no definition under income tax of a living trust. Under income tax, it's all private trust and public trust. So it's a private family trust only. Living trust we speak about when we talk about testamentary and living trust. So one is testamentary trust, which means you write a trust, you create a trust in the will. So you write it in the will. And one is the living trust which you form when you are living. Okay, so it's just the definition. Income tax doesn't have any definition of living trust. So whatever taxation laws is applicable to a private family trust, the living trust will have all those taxation laws.
Next one is, how many legal guardians can we appoint? Any rules?
Okay, so there are certain rules. One which National Trust website also you can find, there are certain rules. You can appoint one as a legal guardian, or you can appoint two people as a legal guardian. I don't think more than two is beneficial in any case. Okay, and probably won't be also appointed. Second, it also depends on who is the child. So National Trust has a very clear rule that if it's a girl child, then you cannot appoint a single male as a legal guardian. Okay, for a girl child, it's always has to have a male and a female. Okay, that very clearly says. So I think two is what the number you can take it, that you can have a joint guardianship, but you can't have more than two, and it won't work. More than two even doesn't work as a guardianship.
Anybody, any other questions? We are open to questions. And also, if you could write in the chat box, Mr. Solanki, your email ID, so anybody wants to get in touch with you, they can.
Yes.
So
Hello,
there's
sir.
another.
I have got one question.
Yes.
See, in case of the special needs children, that
Yes.
what you told was the natural guardianship ends when they get major. Okay,
Yes.
because these people having a problem, how they
Yes.
can be considered as a normal once they cross 18 and that
Okay.
natural guardianship ends like.
Okay. Okay. So see, understand one thing. First of all, guardianship does not have a definition of special needs. Okay, guardianship talks about three guardianship. One is natural guardianship, one is testamentary guardianship, and one is a guardianship of a person who is not able to take a decision on his own. Okay, we call it in the legal definition, unsound mind or incapacitated, that person. Natural guardianship as per law is only up till 18 years of age. After 18 years of age, a person is an adult. I'm not talking about of the disability here, but person is an adult. Under the law, person is able to take his decision on his own. Like you and me, once we are 18, our parents are not a guardian. Okay, nobody takes a decision on our behalf. So your child is also considered on that. Now the law says that if he is not able to take a decision and you want to take a decision on his behalf, then you have to become a legal guardian. You have to get that legal guardianship certificate. Then only you are authorized to take a decision on the child behalf, because he is considered as an adult not able to take a decision on his own. Okay, so that's why the legal guardianship post 18 comes into picture. Okay, so by definition, by law, once an adult, you are, as an adult individual, you can take your decision. But if you are not able to do so as a person and somebody else would take a decision on his behalf, then he has to take a legal guardianship certificate. So it's a legal certificate, a legal document certifying you that you can take a decision on an adult's behalf.
Okay, there's another question in the chat box. Is private family trust separate entity under IT Act?
See, under income tax, yes, a private family trust is not a separate entity. Generally, it is considered as an AOP, association of persons. But based on the structure of the trust, the taxation applies. Largely, the trust is not a separate, entity. It's a legal arrangement. Trust don't have an income of its own. A separate entity means an entity have an income of its own, like a private limited company is a separate entity. Okay, trust is not a separate entity, it's a legal arrangement. Whatever the income is derived in the trust, it is income of the beneficiary. So either the trust will be taxed at the beneficiary level under income tax, or it will be taxed at directly at the maximum marginal rate, that is around 30% with certain exemptions. There are only two kind of taxation which are there in the trust. Okay. Beyond that, the trust don't have an income tax slab. They don't have their own income tax slab. Nothing is there of a private family trust.
Yeah, there are many people who are asking about the soft copy of the presentation, if that's possible, and also your email ID. And
We I we have already recorded this also, so you can
yeah,
very well
and there's
use
another
this.
question. Can a special needs individual operate a bank account even when he or she has a legal guardianship?
Okay. Now, that's a very tricky question, because one is the emotional aspect and one is what the law says. Now, legally, if you look at, so if a person has a legal guardian, okay, that means it's already proved that he cannot take a decision on his behalf, okay, on his own. That's why a legal guardian is appointed. So if somebody can't take a decision on his own, it will be very difficult to operate a bank account. But what happens is that one is one bank not connected to another bank, so it might happen that when you go to a bank, the bank person, the executive, would take the signature of your child and will open a individual bank account. Okay, so that may happen. But if you look at from the legal perspective, might not. But yes, only one situation it may happen, that when you have a limited guardianship. So which means it is proved that he can operate a bank account on his own. So you have not been given a guardianship for his bank account operation. Okay, you have been given a guardianship, say, for only for property matters. In that manner it can happen, but limited guardianship won't apply in these cases. And because for a limited guardianship, the consent is required of the your child. Now your child cannot give a consent that who's going to be my legal guardian. Okay, so it's always about full guardianship. If you have a full guardianship, probably it is difficult. You might still open a bank account, you might still give him to it, because as I said, bank executives many bank executives won't have knowledge on this, so they would just open account. They might open account on thumb impression also. Okay, not even signature. But you have to decide, that whether you want to give money management to your child or not. On that basis you can take a decision.
My name is Rajgopal. I was the one who raised this question, and
Okay.
the reason why I'm asking this question is, uh,
Yeah.
so when I had opened a PPF account in my son's name, this was almost
Yes.
13-14 years ago, when we didn't even know that he was on the spectrum. Okay. Now,
Hmm.
subsequently, we got to know he's on the spectrum. We have taken the UDID, disability certificate. All those things are done. Now he's
Yes.
16. He's going to be 18 in a couple of years' time. And in all
Hmm.
probability, the PPF account is also due for withdrawal stroke extension. Okay.
Hmm.
Now,
Hmm.
at that point in time, so the question is twofold. One, do I need to disclose to the bank that my son is a special needs individual? Number one. Number
Hmm.
two, if I disclose that he is indeed a special needs individual, do
Hmm.
I need to take a guardianship first and then disclose this to the bank, or do I continue to sort of allow my son to operate the account more so in terms of just being able to sign? He is able to do that. So,
Okay.
in
Okay.
such a situation, what would you advise a client?
Okay. So let's understand, if suppose you are not disclosing, which means from a bank perspective, he's an individual like you. Okay.
Correct.
You are in no way taking a decision on his bank withdrawal.
Correct.
Okay. You are not authorized to take that decision because he is considered as an individual. So even if it is withdrawing a large sum of money or deposit, he has to sign and he has to take that decision.
Correct.
Okay. You can't do that.
Correct.
So if so from that perspective, legal guardianship might not be required. Okay, but if it is not going to happen, he cannot take that decision. Suppose PPF has got 18 lakh, you want to withdraw 10 lakhs, let's say hypothetically. Okay, can he go to a bank and withdraw 10 lakhs? No, probably not. Okay, you are the one who is going to do that operation. Now, if you are going to one who is going to do that operation, yes, legal guardianship is required. It will be the account under legal guardianship. It is not going to be an individual account. It is going to be an account under legal guardianship. And to do that, you will have to first take a legal guardianship certificate, because to open an account under legal guardianship, bank will need a legal guardianship certificate.
So if I understand you rightly, what you would advise is, once parents take legal guardianship for their children, they should
Yes.
intimate all the banks that for their sons or daughters they have taken legal guardianship, and that has to be obviously communicated to them. And on that basis, the account will then get operated, right? And that in a
Yes.
way protects the beneficiary from any possibility of financial loss.
Yes, I would advise that, because when you are very clear that he cannot do the money management, you will have to do the money management, then probably manage it everything under guardianship.
Next question is, okay, this is again a little tricky, and you may not probably have an answer for this. Can a legal guardianship be revoked in the sense that if I believe that my son is now capable, or my daughter is capable, because let's say I have trained my son, etc. See, it completely depends upon the extent of challenge
No,
which
no,
a certain individual may
I
have.
agree.
Yeah.
I agree.
So
Yes,
can that be withdrawn?
the court will decide. It's not
Okay.
easy that you will have to just, you have to file an application in the court, mention it that my son is well now, okay, he can take a decision. The court will have the, see, how does it happen?
Yeah.
Let me give you an example, because we have handled these processes. Okay, when you apply to a district court for legal guardianship, the district court sends for a medical assessment.
Correct.
Okay,
Correct.
to take a proof that yes, guardianship is required. After that, the guardianship is given.
Assigned.
Now you go reverse to it. You go to a court and say, no, I do not need any guardianship now. My son can take decision. So court will do an assessment at that point of time and will take a decision that this guardianship is not required. Okay. So it's not a simple procedure that you can just revoke it, whenever. I think it will depend on the court decision.
Okay, fair enough. Thanks for clarifying that as well. And my last question is, can a financial planner, or let's look at it from this perspective, that a settler decides to settle certain assets into the private trust. Okay. Now, in terms of managing the financial, in terms of managing the trust, obviously there will be different settlers who might have a certain investment plan in their mind. But let's say, purely to ensure that the trust does not go out of pocket in any form, it can't be managed as a pure debt oriented trust. You might have to have some additional income benefits which might accrue over a period of time. Do you think, or would you advise that parents should include a financial planner to be a part of the private trust?
No, it's not necessary. See, once a private trust is formed, okay, now a private trust can hire professionals for their work. So they can hire a chartered accountant for filing return. They can hire an investment advisor for managing investments. Okay, they can hire professionals. So it's not necessary you involve a financial planner as a trustee or something. Yes, I mean, you want to name somebody, you can name it. Otherwise, but once the trust is formed, the trustees can decide and hire a financial planner. So trustees will, so what will happen, that the trust will have an arrangement agreement with the financial planner, for the role of financial planner, and all terms are agreed. So much like you and me works with a financial planner, the trust is going to work with an investment advisor or financial planner.
Okay, understood. Thank you very much. Thank you.
Hello, this legal guardian can be many people or only one or two?
Ideally, it will be up till 2. I don't think more than 2. The court will also be comfortable with that. Okay, it can be. There is nothing written that are legal. Only 2 people can be appointed. There can be 3 also. But the courts will look at the viability. Why we need a 3 people to be appointed as guardian? Because operational wise, it might be very difficult for 3 people to operate.
Okay. Okay. Thank you.
There's another question in the chat box. At the end of the trust, when the special child is no more, what is the practice of distribution of the wealth of the trust?
Okay, so when you are forming a trust, you are in the trust deed itself, parents are deciding on this aspect, that after the lifetime of the child, where the asset will go. Okay, like many parents who have formed a trust deed, they have given it that after the child lifetime, the money will go to the charity working with the same children, right? Or some parents have already decided that this money will go to these people in my family. So you as a settler, when you are creating the trust deed, at that point of time, you decide and it is written down in the trust deed.
Yeah, we are still open to question. Anybody else? Quickly, we can take, I think, 1 or 2 more.
What is a typical time to take or get a legal guardianship? Very difficult to answer. Depends on state to state. So when you apply to a national trust, it might take, time of 6 months or 1 year. We are seeing parents, were stuck up for 1 year also. So that is there. And if you are going to a district court, then it totally depends on the court hearings. Okay, so very difficult to say, but I think you take it around 6 months time.